Good evening. Thanks for joining us for the February 2025 Labourlaw monthly update. In this week, in this month, we would be seeing on the topic in the knowledge corner, we would be seeing on a topic called uh, what happens if something were to date back and how courts have seen on a principle on that aspect. To starting with, um, not many amendments, just one amendment by the Karnataka Labour Welfare Fund. Last month we saw it for a society. This month they've made the amendment and they've increased the contribution rates that is payable by the employee, employer, and the government. And the circulars and notifications, this is pertaining to exempted trust. So when you have an exempted trust, normally they don't get reflected in the portal of the EPFO, but now they have made provision for even exempted trust members to be uploaded in the portal, and they are given a timeline to be done. And also it is to be done with retrospective effect. So from August 23, all the data would need to be fed in into the portal, even by exempted trust. The Supreme Court recently felt that the implementation of the sexual harassment of women at workplace, the POSH Act, has not been done well. There's already the SheBox portal where employees are required to register. Following this, different state governments have been issuing directions on the implementation of the Supreme Court guidelines. The Delhi administration has issued a circular where it has asked all the district in charges to ensure that the employers have an internal committee, and also has directed the authorities to inform the employees about the SheBox portal of the government. In the EPFO, again, if a member has been wrongly linked to an employer, the member could then try to delink any incorrect information or linking to an employer to whom he is not worked. The Chennai Corporation has issued a notification calling upon employers to pay the professional tax. This is a reminder for all employers to ensure payment of professional tax. Under the Karnataka shops and establishments, the registration charges have been amended, and renewal charges for the registration has been increased substantially. The quiz segment, as we move in, the question that for you to consider and answer in the chat box is whether the central board constituted in the EPF Act can reduce or waive damages levied on an establishment by the EPF commissioner or the EPFO. Do please key in your answers in the chat box. Across the globe, there is a deemed resignation that's been brought in, wherein if an employee doesn't turn up for work for 15 days, then he is deemed to have resigned or voluntarily resigned and left the services of the employer. But of course, there could be reasons which prevented the employee from coming, and such cases could also be, those are excluded. But this is a provision where if some employee doesn't come for 15 days, it is deemed resignation. Whereas in India, if you look at the legal system, looks at it in a different manner. Courts have held even if an employee doesn't come for 15 days, it is for the employer to initiate an inquiry, issue a show cause notice to him as to about his absence, and only thereafter any proceedings can be taken. But here we have a different system in Italy where they say if he doesn't come for 15 days, he is deemed to have resigned and left the services of the employer. In Germany, the question of hand signature orders of appointment or any contracts has been done away with. They're providing for digital signing. In this manner, India is already far ahead because of the Information Technology Act, where the documents could be already digitally signed and doesn't need to have a ink on it, as they have put it. Slovenia joins the list of employer countries which requires employers uh, to not disturb employees during the rest periods. This is a case where the employer was not in a position to pay the damages on time. As a result, a contribution on time. As a result, damages were levied on the employer. The tribunal reduced the quantum of damages, and the High Court also upheld it. Ultimately, the Supreme Court also upheld the order of the tribunal of holding damages at 5%, saying that when there are mitigating circumstances and factors which had to be taken care, and they could not just mechanically put in the damages part, there should be some discretion exercise in cases to see where there is mitigating factors in favor of the employer. So ultimately, Supreme Court dismissed the EPFO's special leave petition and confirmed the order of the tribunal and the High Court. This is a case of gratuity where the employee, nearly 7 years after the date of his dismissal, makes a claim for gratuity with interest. Ultimately, when it went up, the employer said that it had suffered a heavy loss owing to the conduct of the employee, but then it had not taken any procedure to forfeit the gratuity or to recover the amount of loss that it claims, because the loss caused by the employer is running into around 1.71 crores, but the gratuity amount was only around 788 or so. And then the question, only after the employee filed the application for gratuity, the employer took a position that it was adjusting it towards the loss caused by him. This was not appreciated by courts, and they said that you should, if you wish to forfeit gratuity for the loss caused, you should have followed the due process by issuing a show cause notice, and only thereafter you could have uh, forfeited the gratuity towards the loss suffered by the employer. The concept we are going to see today in the Knowledge Corner is called as doctrine of relation back. This is where certain things are put back in perspective as having occurred at an earlier point of time and from that date. So the first case law that we are looking is PH Kalyani was the reference. In this case, the employee was dismissed from service after an inquiry. There was approval filed by the management. There was a complaint filed by the employee. The inquiry was held to be defective. Thereafter, the management adduced fresh evidence, and then the labor court came to the conclusion that the dismissal was justified. A ground that was being raised by the employee was that because the inquiry was held to be not fair and proper, he would be entitled to salary till the date of the award was a ground that was raised. The Supreme Court negatived it and said, applying the doctrine of relation back, it said once the dismissal is upheld and approval is granted, it goes back to the date on which the actual dismissal took place. Thereafter, in Deshraj Gupta, there was a slight deviation from this principle, where the courts came to the rescue of the employee and said that once the inquiry is held to be invalid and then the employer comes to adduce evidence, the termination will only be prospective and therefore the employee will be entitled to the benefit till the date of the order by the labor court or award by the labor court. The award again here was challenged. The order of dismissal was upheld ultimately, though the inquiry, there different questions came about. I won't touch much upon these cases because ultimately the Supreme Court concluded that yes, an employee, let's assume, is dismissed in the year 2020. He raises a dispute. In the dispute in 2023, the Labour Court comes to the conclusion that the employee is not guilty, or rather, the inquiry was not conducted in a fair and proper manner. The management adduces evidence, and 2025 an award is passed. The award, if it's to uphold the dismissal, it will relate back to the date on which the approval was filed or the first termination order was passed. This is the concept of relation back that you will find in these judgments. We will, of course, circulate you the PPT of this, the presentation that's being made today. So these are different questions that keep cropping up on relation back. These are more a retrospective effect rather than saying relation back. So there is a subtle distinction between what is retrospective, that is, courts can grant relief even for earlier part, and it's not necessarily a prospective implementation. It could even be retrospective. Vis-a-vis, what is it that you know? So what happens is, if the dismissal is if the inquiry is held to be not fair, and the employer adduces evidence, that's the cases where the relation back theory is applied. Not in all cases. In other cases, it's only retrospective effect. This is the case where initially an award is passed in the year 1962. That order is set aside. Then in 1966, a fresh order is passed by the tribunal. The only question before the Supreme Court was the tribunal granted relief from 1965. The question raised there was whether it should be 65, 66, or it could be 62 when the original award was passed. The Supreme Court said that the tribunal can pass an award dating back even to 1962, so it could have a retrospective effect. But considering the facts of the present case, in that case, it said the award will be prospective from 1965. So this is a very, very old case on the doctrine of relation back, or rather, this is more on retrospective effect of an award. Moving on to the Lex Posh segment, we are looking at a case where there were allegations against a delivery manager. The IC found him guilty. The employer removed him from service. He filed an appeal before the labor court, stating that the CCTV footage was not made available to him. He was not allowed to cross-examine the complainant, and the labor court set aside the IC's decision, citing violation of natural justice. Ultimately, the High Court, however, said that such technicalities cannot be seen in a posh case. IC was a quasi-judicial authority, and procedural irregularities cannot be looked into in a posh case, and found that the IC's recommendation and the findings were correct and held the employee to be guilty. The answer to your question is yes. The central board has the power to waive damages, predominantly in cases where the establishment has been declared as a sick industry. But of course, the SICA Act itself is no longer a valid law. But yes, there is a provision under the EPF Act even for the Central Board of Trustees to waive the damages. This is the complaints calendar for February, your coming month. We shall forward the PPT to all the participants. We hope that this would be useful to you. We look forward to meeting you again on 3rd March at 5 p.m. Thanks for joining. Have a nice evening.